In Singapore, we have the Building and Construction Industry Security of Payment Act that came into operation on the 1st of April 2004. And in Malaysia, we have the Construction Industry Payment and Adjudication Act that came into force on the 15th of April 2014. Now, the points that I'm going to be describing, I told Trung earlier on that I have a paper that's about 5 or 6 pages long with the hyperlinks of all of those, what I'm going to be speaking about. So take a look at it. I'll send it through to you so you can take a look at it and you have reference material on what Singapore and Malaysia did, right? So if you take that and let's take a look at Singapore's Act. Section 9 of the Security of Payment Act is where pay-when-paid clause provisions are outlawed, so to speak, and it's no longer allowed. The position before that, the legislation came in, there was a 1979 case, a 1997 case, Intrapo, where the court considered the provision in the contract, and the court said, very simple, the contract, it's very plain meaning of the clause that the plaintiff was not entitled to any payment unless the defendant was first received such payment. So the clause in the agreement says that, and you cannot run away from it. The court also noted that when you talk about pay-when-paid clauses, it's common at that point in time, this is 1997, it's a common industry clause, which must be accepted by the parties with the knowledge of the risk allocation. So you look at it, I think that's another point that Professor Rudy had said right in the start about a risk allocation and where it's allocated. So in the late 90s, we had a position that, that's what the contract provides. That's what the risk allocation is. It's not about, as Professor Rudy had said, he says it's not about the individual, it's about collaborating and all that. We've moved to that. So in the old days, it used to be very strict and, liabilities are imposed on you, you bear it, nobody else, I don't care. Only when I get paid will I pay you and so on, right? So that's what happened. So then what happened was that we then went into looking at passing a legislation mainly to deal with the dispute resolution mechanism of adjudication. It stemmed from UK in 1997, the Housing Grant Act. It came from the New Zealand and Australia, and we started looking at it. And in Parliament, 3 ministers, they spoke about it, and this is some of the things that the minister spoke about. And he says, it's one undesirable consequence is that the subcontractors who has completed the works may not get paid for it because the principal withholds payments from the main contractor for reasons unrelated to the subcontractor's performance. So the principal doesn't pay the main contractor, so the main contractor doesn't pay the subcontractor. But really, that payment is not related to the subcontractor because the subcontractor had gone to do some work, right? Subcontractors may not even be aware whether or not the principal has paid the main contractor, right? And it was really a question of the old system was a bottom-up financing system where, only when I get paid and so on. So that was really undesirable. And he says it was really an imbalance. If a contractor has done the work, he should surely be paid. Another minister also said that, it's a deep structural problem, right? And the problem of building contractors, particularly subcontractors, not getting paid for work done for months or sometimes even years. And it was a deep-rooted problem. And this act was there to try and eradicate that problem, take away the problem. As long as a contractor has done his work, he must be paid, right? And the well-known old school method of pay when paid and all should just go out the window and it should not be allowed. So essentially, that's what the minister said about the act, and that's how we implemented the act and we put this a legislation in place. Professor Rudy repeatedly said, you got to legislate, you got to show them, not just tell them what the problems are, show them how am I going to solve the problems, right? And you've got great examples, Australia, New Zealand, UK, Singapore. And if you use these examples, it's very easy for you to frame the legislation that you want. So for example, the New Zealand Construction Contract Act and the our Singapore's Act is kind of similar in the sense that it provides clear consequences of the inclusion of conditional payment provisions, not merely rendering them ineffective, but making it unenforceable as well. So the point is this conditional payment that only once I get paid that you will get paid is really something that needs to be eradicated, taken away, right? And so go take a look at the legislation like New Zealand and Australia, and it gives you clear guidelines. Now, if I then turn to Malaysia, right? Malaysia had this Construction Industry Payment and Adjudication Act 2012. It's section 35 of that, it's called the SIPA, and it provides that any conditional payment provisions in the construction contracts in relation to payment is void, right? And it then explains what conditional payments are. It's that a party having received payment from a third party doesn't then pay it forward, all right, or only pays it forward if it does receive the money, and that was considered a conditional payment. And Malaysia said, we don't want that, right? And then they put the legislation in place. There's section 5 of the Malaysian provision that says that that unpaid party can claim for payment of work done and services rendered under the express terms of a written construction contract. So it gives the subcontractor who hasn't been paid solutions of how to go get their money. So what you'll see is that what Singapore and Malaysia has done is that they put in a legislation framework that is fair to the parties. It comes back to what Professor Rudy has said. It's about being fair to the parties. And you know what? If you honestly think about it, you know, I've come on the job, and surely I must be paid for what I've done. Don't give me excuses that you've not been paid and so on. Then you should have never hired me in the first place, right? You hired me to get a job done, and I'm doing the best job that I can. It is only fair that you treat me as an equals to some extent, you know. And that comes back to, again, Professor Rudy's point about collaboration. You know, there's this great movement forward about contracts being a lot more collaborative, right? And people sharing risk. You know, the old school theory of saying, no, the contract is, that's what our contracts are about. The contract, you're responsible for it, and therefore you take care of the risk and all. But, you know, the world is changing. And I think COVID-19 has shown us that if we don't come together, work together, share the responsibilities, share the joys, share the goals that you achieve, you're really going to be in a tough position. You know, a lot of people have been saying that coming out of COVID-19, there's going to be a whole lot of disputes and to be settled. I don't think so. My take is that there are going to be a whole lot of issues, but people want the issues to be resolved. They don't want to go to court. They don't want to go to arbitration. They want different methods of dispute resolution that can get people to the table to come to a solution that everybody is happy about. And that really is a definition of what collaboration is going to be about. So if you use that framework and tell yourself, really all these contractors that we have that are doing small work, small projects, we really need to be fair to them, right? And if you keep that in mind, you keep that 4 key elements of what a professor had highlighted about being fair, about the certainty, it's very easy for you to set a framework and a legislation that can take you through to a framework that avoids pay when paid clauses, right? Now, you know, you had asked Professor about amendment changes and updates to the provisions. We in Singapore, while we had the act in place in 2005, it only last year or the year before, that is almost 10, 15 years later, that we have made changes to the act. Right now, some of those changes, none of those changes have any effect on the pay when paid clause, because that is entrenched now, and everybody knows you can't do it. But there have been changes made. So, you know, I think Vietnam is in a really good position to be able to take this forward, right? Set a framework, set the objective, and I think, you know, in everything that you do, you always must have what is the reasoning behind it, right? And the reasoning is exactly what Professor talked about. He talked about fairness and certainty. If you set that as your benchmark, then explaining the legislation that you want to put in place is going to be incredibly easy, right? You know, of course, when you frame it, you must take into consideration some of the nuances that can cause problems. Like, for example, in the in Malaysia, there was a question whether or not the Act takes into effect retrospectively. That means contracts that were pre-existing contracts before the Act came in place, whether it applies to those, right? Initially, the courts had taken a position that yes, it could be retrospective, but later on, the courts now have said that no, it's prospective. That means it's forward from the point of time the Act came into place, and then it works forward. So please do keep those nuances or the small little things in mind when you're starting to draft. But I think, you know, I myself have learned a lot from Professor, because he did what is so critical in everything that we do. Always, because I do a lot of litigation, I call it our case theory, right? When you're going to court, whether it's an application that you're arguing or whether you are in trial, you must have what your case theory is. And so that you can argue your case on that basis, you can take the cross-examination on that basis. Anything and everything goes on that case theory. So, and so far as pay when paid clauses are concerned, the case theory must be about fairness, about certainty, about doing the right thing as far as the country is concerned or the economy is concerned. All right. And I think that's it. That's what I have to share. If there are any questions, I'm happy to take them. Thanks, Professor. Really insightful points and of how you know, you can take this forward.
Can I